Supreme Court. Please be seated. As you note, the Chief Justice is not present this morning. He is involved in one of his other duties as a member of the Constitution Revision Commission that is meeting and voting today. That does not mean that he will not participate in the cases that are on the calendar this morning. He will participate in the cases. I think you all know that our oral arguments are both audio taped and videotaped, and both the audio and the video will be available to him. The first case on the court's calendar is the case of Robert F. Milligan, Appellate versus Palm Beach County. Counsel for the appellant may proceed.
Good morning. May it please the court. I'm Deborah Guller, representing the Comptroller of the State of Florida. This is Harry Hooper, General Counsel for the Office of the Comptroller. For at least 63 years, Palm Beach County has been paying, pursuant to its statutory mandate, the appellate filing fees for indigent defendants. In May of 1993, Palm Beach County ceased payment. Procedurally, this case is before this court on an issue of great public importance. In May of this year, the Department of Banking and Finance filed its complaint for writ of mandamus, demanding that an official pay to the clerk of the 4th District Court of Appeal the appellate filing fees for indigent defendants.
Ms. Guller, let me direct your attention so we can get right down to the nub of this, since I've been having a lot of fun trying to understand 939.15. I'd like to ask you some questions concerning it. This statute, you would agree that it's 939.15, which is the threshold law that you're depending upon. Now, in this statute, it says that when a defendant is indigent, or when the defendant is discharged or the judgment reversed, the cost allowed by law. Now, I want you to tell us what is your definition of what a cost allowed by law is.
Okay, pursuant to Appellate Rule 9.400.
Well, now that's not a law, is it?
It's a rule.
It's a rule. Okay.
That's correct.
Tell me what is a cost allowed by law.
Okay, taxable costs have been defined by...
Okay, so you're defining it as taxable cost.
That's correct.
Okay. Now, and so then where is an appellate filing fee defined in the statute as a taxable cost?
In the statutes, it's more defined in case law, and I was going by the appellate rule, which states what a taxable cost is. Since we're dealing with appeals in this case, appellate filing fees, the rule defines it. And then I cited two.
Well, then what you're telling me is that there is no statutory statement
definition
that defines a filing fee as a taxable cost. Is that your position?
I haven't recognized one, that's correct. But it's the state of the law today that the filing fee are taxable costs. If you reference the cases that I cited in I believe it's my reply brief, there's numerous references where the courts have incorporated under the umbrella of costs appellate filing fees. So it's assumed into the law. And we're not talking about, these are fees that do become part of the process.
Okay. Let me move you on to the issue of the next sentence. If we accept for the moment that a filing fee is a taxable cost by reason of case law as opposed to statutory law, what does the sentence, however this section does not apply to indigent defendants represented by the public defender. Now, what does that mean?
Okay, that sentence defines what it modifies the sentence that comes right after that. If you look at what it's saying afterwards, in such cases, so that's defining what the first sentence says, costs incurred pursuant to 27.543 shall be paid by the county, and what they're talking about, if they are necessary and if they are reasonable. These are discretionary costs and expenses that are cited in 27.543. You're talking about expert fees, travel expenses,
You would agree
investigative costs.
that in 2754.3, it's silent as to court filing fees.
No, because they're talking about discretionary spending, and under those circumstances, the discretionary spending needs to be rationalized. They have to certify that, yes, this is necessary. You're going to have expert fees maybe for something that's not necessary. In this case, the county is given the opportunity by that amendment to say, wait, that's not reasonable. If you look at the record, page 16, in the legislative analysis of this, it says the bill, it's to remove the court order requirement for establishing county liability, and they talk about the certification. Now, there's nothing in filing fees that is discretionary. It's mandatory, it's necessary. So
Let me, while you're
Yes.
on that point, it's mandatory and it's necessary?
Correct.
All right. Are you familiar with 57081?
Yes, I am. Now,
No, why should there be a filing fee required at all? In other words,
Okay.
both in terms of the provisions of that rule and in terms of good sense, that is, and especially when we're going back to the phrase that we were discussing about indigent defendants represented by the public defender's office. All right. Now we've narrowed it down where, to the extent that the government can do it, we now have a class of defendants who have been officially declared to be indigent, therefore unable to pay fees.
right.
And they have a right to appeal.
Absolutely.
Okay. So why shouldn't we read 57081 combined with that language that we just referred to, and mixing in a little bit of good sense to say that there really is no reason for the fee to have to be paid by the state or the county or anyone, that the fee should be waived if we read those in the context that they're offered. Is your client adverse to a ruling like that?
What 57081 and arguably 924.17 say is that the filing fee, you can either argue that prepayment is not mandated, or assuming arguendo for a moment, that payment is not mandated at all. What those sections do is say that the indigent appellant need not pay those fees. Those statutes do not relieve the county from payment. We still have 939.
It doesn't say that the fee is waived, that filing fees are waived?
Our interpretation is that prepayment, they do have...
What are the words in 57081?
Okay. I do have it here someplace, and I know what you're saying. But assuming arguendo that they do waive fees for the indigent appellant, okay? Let's say that's what the statute says. In no way does it relieve the clerk of the court from collecting those fees, which the clerk is mandated to do by statute and by rule.
Well, why would the clerk be mandated to recover a fee that has been expressly waived by statute?
Well, that's just it. It's been waived perhaps for the indigent appellant, but it hasn't been waived for the county.
Well, but the statute says if we assume that 57.081 means exactly what it says, because it says any indigent person who is a party in any judicial proceeding or who initiates such proceedings shall receive the services of the court with respect to such proceedings without charge.
That's what it said.
Yes, but it doesn't say the county is relieved from this responsibility. And then we run into a policy question for the legislature to handle.
Well,
But
how
it specifically-
more straightforward could the language be? I'm having a lot of difficulty here with putting a gloss on something that appears to be very straightforward. Not only appears to be very straightforward, but also appears to make eminent good sense. That is, why should any branch, we're all in this thing together, so to speak, as far as taxpayers and the system. So why, when we are trying to afford due process and the right to appeal to indigents, why should we be cross-billing one another for these costs when we have that rather, at least as Justice Wells was reading it, it seems to me that that's about as unambiguous a statement as you can get. Why does the comptroller feel that that is not good policy?
It's not the comptroller's decision to determine the policy. Our interpretation is that the law mandates that the county pay, and then rather inartfully perhaps, the legislature has said that these costs pursuant to 2754-3 have to be rationalized and certified as necessary because they're discretionary. Filing fees are not discretionary. They're mandated by rule and by statute. The county, in this first sentence of 939, is mandated, the wording is, shall be paid by the county. There's nothing discretionary about that.
In section 2754, parent 3, is there anything in there about filing fee?
Absolutely not. They're discretionary costs of the public defender's office. They're about expert witnesses. There's investigative costs.
How does that have anything to do with filing fees?
The first sentence in 939 has to do with that. Now, what the legislature has done, and it could have been written better,
Which sentence covers filing fees?
the first sentence.
Would you read that?
Yes, when the defendant in any criminal case pending in any circuit or county court, a district court of appeal, or the Supreme Court of the state has been adjudged insolvent by the circuit judge or the judge of the county court upon affidavit and proof, as required by 924.17 in cases of appeal, or when the defendant is discharged or the judgment reversed, the cost allowed by law shall be paid by the county in which the crime was committed upon presentation to the county
I'm sorry,
commissioners.
maybe I didn't make that clear. I was talking about your reference to 2754, parent 3, toward the end of the statute,
Correct.
which seems to exempt public defenders, but then it says, and I think your response to that was, no, public defenders then are handled under 2754, parent 3, but I look at parent 3 and I don't see anything about filing fees.
That's correct. Those last two sentences relate to public defenders when those costs pursuant to 27.543 are incurred. These, as I'm trying to explain, those costs are discretionary costs. The county the public defender's office has to say that they were necessary under the circumstances. And the background to the amendment, if you look at the record, page 16, and the pages prior to that, the legislative analysis goes on to say that this was necessary because there were costs that were being expended by the public defender, yet they were being certified as necessary by the circuit courts, and these costs were not always necessary. And they needed a mechanism in there to say, yes, are these costs necessary? I mean, they're expensive. They're discretionary and they're expensive. How much traveling does a public defender do? How much, what expert witness fees are necessary? So the dual purpose of the amendment was to have them certify as necessary these costs and gives the county an opportunity to say, wait a minute, we don't think so. Okay, so the amendments, inartfully written perhaps, just relate to those expenses, and it's a mechanism to say these are necessary, these are expenditures. The county still pays them, but they have to say that they're necessary, and the county has to agree to that.
You're substantially into your rebuttal time as you designated, and I didn't know whether you knew that or not with that yellow light.
Okay, I'll reserve the rest of my time for rebuttal.
Good morning. I am Dan Hinman. I have the pleasure of representing Palm Beach County, Florida today. My co-counsels are present. First, I'd like to briefly introduce Anthony Musto, representing Broward County, who will address the court today if there's an opportunity. My other co-counsels are also present: Jason Block from Dade County, George Dorset from Orange County, Herbert Thiel, Leon County, Suzanne Smith, Pinellas County, and Patrick Kinney, also from Leon County.
Let me ask you to begin with, Mr. Johnson, do you agree that costs allowed by law equate to taxable cost?
They can, in certain circumstances.
Well, in this
equate.
statute,
No, sir.
you don't agree with it?
No, Mr. Justice, I don't.
Well, what then does the reference to when the defendant is discharged, the cost allowed by law?
Yes, and
doesn't
that
necessarily refer to 939.06?
Yes, in that isolated case, that taxable costs, and I guess that statute also mentions fees of ministerial offices as well, which is a totally
And in
different.
Sawyer, this court said that these costs
Yes.
refer to court fees and filing fees.
Yes,
So
Mr.
if we're going to
Justice.
be, why isn't it true, if we're going to be consistent with Sawyer, and we're going to make this statute consistent, where it refers to when the defendant is discharged,
Yes.
also indigent defendants, and to where a judgment is reversed, and define cost allowed by law, why isn't it taxable cost,
Well,
including court fees as defined in Sawyer?
Mr. Justice, it could be in that very isolated circumstance where there is an acquittal of the indigent criminal defendant, but there's nothing in the statutes that would require that defendant to even pay these fees that the appellant is requesting in that particular case.
Well, how can we consistently define cost allowed by law as meaning one thing in the statute for the defendant where the defendant is discharged, and another thing in the same statute where it is an indigent defendant? How can we do that consistently?
We try to achieve consistency. I don't know if it's entirely possible, if the definition is somehow fluid depending on the outcome. I would also mention, though, that getting back to these particular fees in which is being requested, these aren't even costs of a court. These don't go towards a transcript. These don't go towards attorney fees, costs for an investigator. It's an assessment by the clerk, and it doesn't even go towards funding the court system. It goes into the general fund. I can see where the court would be looking for a consistent argument, a consistent definition for cost, but I think it really varies on the situation.
Well, let me ask one other question here, and that is, why isn't Judge Harris's statement right? I mean, that there is some precedential value in the fact that this is the way that the counties have done business since the 1950s.
And the court is referring to the Batson decision
Right.
by the Fifth District Court of
And that
Appeal.
just by growing up of custom and usage, that rather than throw this particular part into a different category, why isn't it something that this court should do is to respect the way that it's been done for 40 years?
It's a consideration, Mr. Justice. It is a factor. It has been done, but it was based on a mistaken obligation, and the mistake should not be perpetuated. There's a number of problems with the Justice's opinion in that Batson case. If I could just outline those briefly, I found 5 major problems with that, and it really comes down to our major point is that there is no statutory mandate. Mr. Justice Wells, you questioned the appellant on that. She was not able to find any statutory mandate because there is no statutory mandate. But getting back to the Batson decision, which you mentioned, there's a number of problems with that besides the holding. The decision was rendered after this court had jurisdiction of the whole issue. So that's an initial concern. But not just dwelling on that, that court departed from the plain language of 939.15. That statute, as one of the justices here point out, says in black and white that it does not apply to indigent defendants represented by the Office of the Public Defender. The 5th DCA found that it did, even though that's what the statute says. It says it doesn't. They said it did. That's a problem. They also, getting back to statute 939.15, which is the essential statute in which the appellant relies on, the 5th DCA read that statute very broadly. That is a cost statute to be read very narrowly pursuant to Sawyer. But the 5th DCA decided to read costs extremely widely, liberally, and in order to find an obligation for the counties where no obligation existed. They also seem to, the court, in my reading of that opinion, they seem to exist that there was somehow a pre-existing duty that the counties pay these appellate filing fees, when in fact there is no pre-existing duty because any duty must be established by statute. And the statute...
Let me ask you that on the matter of any pre-existing duty. As I understand, this really goes back, and paying filing fees goes back into the 1950s, correct?
That's probably correct, Mr. Justice.
Basically, on up until January of 1973, do you agree that the counties paid all the costs with the exception of the circuit judge salaries? Other than that, all the costs and the expenses were paid by the county, historically, until the consolidation of the court system in 1973.
That could be, Mr. Justice. I don't have an intimate knowledge of every single court cost, but yes, that could be, Mr. Justice.
I mean, the matter of when the consolidation came in on the matter, in fact, one of the big things that came in is the state took over the paying the salaries for the judges' secretaries was one of the big items that they took over. But I mean, up until that time, the only thing that the state paid was the salaries of the circuit judges, and really not all the salaries because the counties supplemented those salaries. At that time, I guess I'm about the only one left that used to get two paychecks, one from the county and one from the state. But I guess my point is historically, on the matter up until that consolidation, the counties paid everything. Is there anything to dispute that historical fact?
From the perspective of history, that's probably correct, Mr. Justice.
All right.
And really, the appellant should not rely on this just historic. I mean, if something is done wrong and under a mistaken conception of the county's obligation, why should it, now that it's been brought to the court's attention?
Do you have an idea of what the total amount in the last fiscal year was transferred from the counties to the General Appropriations Fund?
Pursuant to the payment of appellate filing fees? I can give an approximation. Palm Beach County was sued in the amount of $160,000, which I believe, and the appellant can correct me if I'm wrong, covered a 4-year period of time. So I guess we're looking at an average of maybe $30,000.
Okay, in a metropolitan county like Palm Beach.
Yes, and it varies. It depends on each particular case how many appellate filings there are.
You do agree that really these appellate filing fees for indigents frankly, was not a financial issue until this Gideon versus Weidner in 1963, because you didn't have indigents with attorneys in felony cases until after that time.
That would probably be correct, Mr. Justice. Getting back, though, to the appellees, our main point, there's been a lot of arguments presented in front of this court in the briefs that were submitted by amicus curiae, very well presented, but it really comes down to the question of no statutory mandate. The appellant is trying to create a statutory mandate where none exists. There's an analysis going on with the statutes. There's a in para materia argument, and the more the appellant relies on tortured statutory construction, the further we are getting away from a true statutory mandate.
Well, let me ask you about the statutory mandate, because, and I'm talking a little bit about history and where the statutes are and when statutes were enacted. Because actually in the 60s, there were counties that did have public defenders, but they were funded totally by the counties in county fund. In my county was one of them. So that the matter of where the switch came in, as far as where the state's obligation to assume this responsibility came in, are you saying that it came in at the time the state took over the public defender system?
I think
those counties that had public defenders?
That's part of it, Mr. Justice. I think it's a slow process over the last quarter century. The legislature has put more and more of these costs upon the county shoulders. In fact, since the Article 5 revision. So this is a process that's happened over a number of years. What I would request that this Supreme Court look at, though, is the existence of the statutes, what the legislature has given us today. And they have not given us anything that states that the counties are responsible for appellate filing fees for indigent defendants.
Let me ask you one more question. I'm concerned about our reference to Chapter 57 in that appears really to be a part of Title VI, which is civil procedure. Would you not agree with that?
That's where it's put in.
Has there been any case that this court has ever applied that statute to a criminal context?
This Supreme Court, I can't recall any opinion offhand. I have read, I know, a number of district court opinions in which
I noticed in part of statute annotated, it doesn't even have a criminal reference.
I did find cites to some district court opinions where it was used Thames versus State, THAMES. I think it was 1979 decision from a district court of appeal. That's not our main argument. That's certainly a consideration for the court. And maybe not so much where that particular statute is located in the statute, in the table of contents, but the plain language of the statute. And the plain language of the statute makes it clear that indigent litigants there's no obligation to pay the filing fees. One statute I did want to bring to the court's attention is 924.05 subsection 9, and this is a recent statement of the Florida legislature. It states that funds, resources, or employees of this state or its political subdivisions may not be used directly or indirectly in appellate or collateral proceedings unless the use is constitutionally or statutorily mandated. That and the Sawyer decision are really the poll stars, the guides that we have to look at this case. And what the appellant is trying to do is trying to make the cost obligation as broad as possible, but the law says to make it as narrow as possible, especially where counties, which are political subdivisions of the state, are concerned. We've also brought out that when the legislature wants the county to pay certain costs, they state it in no uncertain terms. They've used the language, shall be paid by the county. They make it responsible for county to pay attorney fees, for conflict counsel, expert witnesses, to subpoena witnesses into court. There's even some examples of, the county is responsible for sanity evaluations, autopsies, pregnancy exams. The legislature states in no uncertain terms when they intend the county to pay these costs. With all these pronouncements, though, there is nowhere in the statutes from page 1 to whatever page the statutes end on, the end of Volume 5 or end of Volume 4, they state no words whatsoever shall appellate filing fees be paid by the county. We have all these definite statements by the legislature. No statement, no statutory mandate to pay these particular fees.
There is a specific statement, however, in the statutes that says that the counties are responsible for all court facilities and personnel not otherwise that are necessary to the operation and not provided by
Right, that's
not provided by the
Chapter 43.
43.
Which I think is limited, I think that's county and circuit courts. I don't know if that applies to district courts, but that's,
It does.
Okay.
It's county and circuit court.
it's county and circuit court. Not to, and we're, of course, talking about fees of the district court, but that is true. Unless this court has any further questions of me, I would like to yield the remaining time to my co-counsel. I would just like to conclude that the lower court did not abuse its discretion in dismissing the lawsuit of the appellant. Counties have shouldered a great deal of burden of the criminal justice system, of the court system, because the legislature says that we do, because there are statutory mandates. Here, in a case where there is no statutory mandate, that burden, that mandate should not be created, and that burden should not be passed along to the counties. And I simply request that this Supreme Court affirm the ruling of the trial court. Thank you.
May it please the Court, Anthony Musto on behalf of amicus curiae, Broward County. I want to focus on one specific aspect of this case, not so much the statutory analysis that has occurred, but on the state's obligations under the Florida Constitution. And I think there's one thing that is very indisputable, it's very simple, and that is the state has the obligation since 1973, as Justice Overton indicated, of providing a court system. The fees in this case are very different than the sort of fees that the appellants have discussed, fees such as travel expenses and so on. This is a fee established by the state, paid to the state. It exists because the state says it exists. It is, at best for the state, money which helps underwrite the very cost of the system itself, not costs associated with the system. And that, at its most basic, is the state's obligation.
Well, can the counties just sleep on their rights and have this?
Well, the counties haven't slept on their rights, and I did want to address that, and I'm going to address it right now. First of all, you talked about going back to the 50s, and as Justice Overton indicated, this wasn't an issue until 1973, so I think we can jettison that part of the analysis from there. And I think this court is very aware that the counties over the years have made an ongoing effort to effect a political solution to this problem. There have been legislative efforts going on every year since this has begun. The counties are certainly entitled to make the determination that bringing litigation could cause damage to those efforts and make a strategy decision as to when it is appropriate to do that. Also playing into that strategy is the fact that these costs have gotten greater and greater and greater. It's over $1 billion a year now, and the counties are paying over half of that.
But what is the portion that we're slicing out here?
I don't know the specifics as far as what goes to filing fees.
So one of the things that concerns me, Mr. Mister, that I'd like your input on is, aren't we just kind of hacking away at an isolated portion here? Are we going to just start doing this limb by limb? Or?
Well, we are hacking away at an isolated portion because that's what the facts of this case present. I think there are broader concerns. And to get back to what you were saying, one of the things I will tell you quite frankly that has been discussed among the counties is a very broad-scale suit against the state to require them to assume all the costs of the system. That hasn't been done for a lot of political reasons. The fact is this case arose. It happened. It came up. It's here. So this is the legal issue that's before the court. And I would ask you in considering this, consider one other thing. If the counties had come in on January 2nd, 1973, when the court system changed and raised the issue then, would you give extra weight to their argument because they made it right away? Of course not. So there shouldn't be any less weight because the counties tried to help the state meet their obligation over the past 25 years.
Well, you do agree that before 1973, the county had a very substantial portion
Absolutely.
of the I mean, they had almost all the obligation
Absolutely.
of the
But they
courts.
also had a much greater role in running the judicial system, and they gave that up in large part because of the promise that the state would assume the funding, and that's a promise that the state has never lived up to. Let me address one other brief point that was made, the Sawyer case. Sawyer wasn't indigent, and that's the distinction. These arguments are entirely consistent with Sawyer. Sawyer, of course, there was a null pros, but if there had been a filing fee, it would have come out of Sawyer's pocket. So that was an entirely different situation. I see my time is up. Thank you very much.
Rebuttal.
I'd like to backstep for a moment to answer Justice Overton's questions. I believe it was the 1885 Florida Constitution that did have a provision. It was, to my recollection, Article 9, Section 16. And then as far back as 1934 in Roll v. State, they cite a law that required the county to pay the appellate filing fee. So this has been the law in Florida for years, and nothing has actually changed. The amendment to 939.15 did not change that.
Well, you do agree that there was a major, major change that occurred in the court system in 1973.
Correct. 72, 73.
I mean, it's in 1972, it was adopted in 72, went into effect January 1st, 1973. But there was a major change in assuming all types of obligations at that time, and just prior to that time, the state assumed the obligation of the public defender system, which was created the public defender system funded by the state as a result of Gideon versus Wainwright and Argensinger. But all those things occurred during a short period of time, and in that instance, that's when the state assumed those obligations, and the state does receive something in return, do they not?
Correct. Okay, the state assumed a lot of the cost. I have combed Article 5, and I realized there was some intent indicated by amicuses and appellees. They referenced that. But I don't see where it says the state shall pay for all these costs. And you must recognize also that the state has provided reimbursement provisions. If you look at Section 27.3455, Section 1 requires the county to account for their expenditures, and along that accounting, they specifically indicate indigent appellate filing fees. And then in Section 3D, I believe it is, the state will reimburse the county for indigent appellate filing fees. And what's also interesting to note is that in that Section 27.3455 sub 3 is that the state reimburses all different costs to the county, first of which are the 27.543 expenditures made. And it goes down a list of expenses that are reimbursed. Section 57.091 reimburses the county for payments for indigent prisoners when they're in prison for their appeals and competency proceedings. There's Section 27.525, I believe, that also sets up
Not just competency proceedings,
and prisoners.
criminal proceedings.
Correct. Criminal. Thank you. And they set up an indigent criminal defense fund.
What happens to the fine and forfeiture funds?
The fine and forfeiture funds are earmarked for payments for criminal fees and cost as well in Section 14201. And
Where do they come to originally?
They
Where
go
do
to
they
the
come
county.
to now?
They go to the county. The state set them up by statute, and they go to the county. And then they are earmarked for criminal expenses.
All right.
Okay, and then there's a 938.05.1, there's another section there that sets up a fine and forfeiture fund that has fines that are charged like for misdemeanors and felonies and whatnot, and those go to the county to pay these criminal costs. So it's not like the state is like pay without reimbursing. We are reimbursing the General Revenue Fund is reimbursing the counties for expenditures, and it's a policy decision between private and public funds as to where the money is dispersed. And about to answer someone's question, about $750,000 a year are expended throughout the state on indigent appellate filing fees. If there are no further questions, I'd just like to re-emphasize the portion of 939.15 that requires the certification of necessity for certain public defender costs, and that the first sentence of 939.15 mandates that the county pay these indigent appellate filing fees. The state has made provision for reimbursing counties for these costs and fees, and I would like to rely on my briefs for the remainder of the argument and ask that this court determine that the circuit court issue its writ of mandate. Thank you.